Chairman, sir, over to you, please. Mr. Chairman, Mr. Abimbola Kayode, can you hear me, please?
Can you hear me?
Yes, Mr. Chairman, we can hear you.
Okay, thank you, Mimi. Good afternoon, my Lord, the Honorable President of the National Industrial Court of Nigeria, Honorable Justice B.B. Kanyip, my Lord, Honorable Justice O.A. Osage, distinguished senior advocates of Nigeria on the panel, senior members of the bar, my distinguished colleagues, ladies and gentlemen. I'm highly elated to welcome us all to this webinar organized by the Nigerian Bar Association Abuja Branch Unity Bar Committee on Legal Practice in conjunction with the National Industrial Court of Nigeria, titled Bar Interactions on the National Industrial Court of Nigeria Practice Directions and Guidelines for Court Sitting 2020. No doubt, this session will bring together all stakeholders and users of the court. It is expected at the end of this webinar that the bar will be more enlightened about this new practice direction, which arose as a result of the COVID-19 pandemic. The array of speakers, ably led by my noble Lord, the Honorable Justice B.B. Kanye, President of the National Industrial Court of Nigeria, my Lord, Honorable Justice O.A. Osage, Mr. Israel Olonodari, SAN, Mr. Dayo Apata, Senior Advocate of Nigeria, Solicitor General of the Federation, my Lord, Professor Peter Apui, SAN, Dr. J.O. Olatoke, SAN, Professor O. Amuche Azi, SAN, Paul Harris Ogbole, SAN, Mr. Nduka Ikeyi, Esquire, Folabi Kuti, Esquire, Regina Okuti Ebo, Esquire, and Olani Anjoni, Esquire, and all other members of the panel. I'm sure will do substantial justice to this discussion. I thank you all for your time. God bless you. Good afternoon.
Thank you, Mr. Chairman, for that brief welcome address. We appreciate your time and with us this afternoon. Distinguished panelists, ladies and gentlemen, may I at this point invite Milord, the President of the National Industrial Court of Nigeria, Milord Honorable Justice B.B. Kanye. Milord, over to you.
Thank you. The who are with us in this session, senior advocates, counsel, ladies and gentlemen, thank you very much for putting up this. In particular, I must thank the Unity Bar for getting in touch with us and x-raying the practice directions that the National Industrial Court came up with, effective Monday, 18th May 2020. It became absolutely necessary that we come out with the practice directions, not so much because of COVID, although we use COVID as an advantage, a stepping stone really, but more given the special nature of the court itself. For even without COVID, we could easily have come up with this same practice directions in the same manner in which it is. But of course, with the pandemic staring us in the face, it became absolutely necessary that we come up with. And what we did was to put up the Judges Committee on Rules and Digitalization to look into it and come up with some draft directions and guidelines. Justice Obaseki Osaga, who is with us today, chairs that committee, and they came up with a draft report. Of course, my membership of the COVID committee of the NJC meant that we needed to await the outcome of the guidelines that NJC would give courts in this regard. And as soon as the guidelines were released, we did a harmonization where we put up both the report of the in-house committee and the guidelines by the NJC. So what you have as the practice directions 2020 of the court is a combination of work of the in-house judges committee and the guidelines as given or laid down by the NJC itself. Now, when you look at the structure of the guidelines, you would find out that it deals with a number of issues which are not necessarily tied to court sitting. We have issues dealing with how people comport themselves even within the premises of the court. We have issues dealing with safety standards in terms of the health of people who use the court and its facilities. And naturally, we have provisions in relation to actual court sitting. And in all of this, we try to also incorporate standards laid down by especially the Presidential Task Force, particularly standards dealing with social or physical distancing, wearing of face masks. So in the practice directions and guidelines, you would see something a little bit unique, novel if you would call it. We are accustomed to seeing practice directions which necessarily are held or tied down to just what happens in the courtroom. But in this, we have practice directions and guidelines dealing with not just what happens in the courtroom, but also outside of the courtroom, particularly in terms of the health challenges that are being posed by COVID-19. But I must state here that the guidelines and the directions itself are not just guidelines applicable now, but they also survive post-COVID. In other words, even if we are to bypass or pass the COVID-19, it's almost certain that the guidelines are with us. The practice directions are with us. And this is principally because as a specialized court, we are caught for speed. We are caught for flexibility and a measured informality. And I think this is where the National Industrial Court is distinguished from the regular courts. There are certain things we do. There is a measure of informality that is required of us that other courts don't necessarily enjoy. So within the context of the special nature of the court, you would find that we have tried to do certain things, even within the structure of the rules, to allow us that measured informality, that measured flexibility to be able to achieve the speed that is required. And even without the practice directions or the guidelines, the key issue we need to note is that in attending to cases before the court, as much as possible, how do we resolve cases even if parties are not physically in the courtroom? What we have tried to do within the structure of the practice directions and the guidelines is principally to be able to put down those circumstances in which we can be able to take cases that we can do without the necessity of people coming around. Of course, we understand that a good deal of challenges are on ground in terms of us doing something that is relatively new. You would see from the rules, particularly the directions, that almost on a weekly basis, we're expected to highlight those kind of cases that we can take within this period. It was only on Monday I issued a directive, a memo to judges and indeed the general public that within this COVID period, taking into cognizance the fact that we're expected to deal with urgent matters that are time-bound, we've been able to streamline those cases that fall within this category. For instance, we've been able to identify issues dealing with strikes. We've been able, not too long ago, we got a case where I think one of the unions was planning a strike, was planning to do elections online, and we had an urgent application which we were able to take just so that it doesn't appear as if people who are involved in matters like this and have complaints and are not given any hearing. We also have issues dealing with strike, union elections, those matters dealing with processes that do not necessarily require oral testimony, like originating summons, originating motions and the like, referrals from the Minister of Labor are also specific cases that are not necessarily being heard. And then yesterday, we were able to add to this category. The National Industrial Court has a special procedure called trial on record. As it is right now, its workability depends on the consent of the parties. So if parties agree to utilize the practice on record, the trial on record procedure, we are prepared to take it even within the COVID period. And naturally, of course, all those matters dealing with adoption of written addresses can also be taken within this period. Here, I must make the point that you would find within the structure of the practice direction a provision that says when filing written addresses, a council can also follow it up with a simple letter saying that the final written address should be deemed as adopted. This is to avoid situations where council will even need to come to court. Where this is the case and both parties file such letters, all the judge needs to do is simply give them a date for judgment. So within the structure of the rules, the key thing for us is how do we cut trial time? How do we reduce the interface of people coming as much as possible? Only yesterday I took some cases for adoption of written address for adoption. And while I sat in open court, all the counsel in all the cases joined virtually. And in one of them, there was even an oral application to discontinue the case. And once the other counsel did not object, we were able to take that oral application virtually and enter an order of discontinuance, and the case was struck out. All of this we are able to do given the current practice directions and of course what we are faced with. I cannot say that it has not elicited concern. In fact, that's the very reason for which we are talking today. I did some tour shortly before the COVID lockdown, and in some of the divisions, lawyers complained that the processes in which we collect money, right now we use the system where remitter is used, but I've gotten complaints that it's a bit cumbersome. Sometimes it's pretty difficult making payments, particularly where such payments have to be done before dates or processes can be processed.
So the OQR is responding.
We are looking into this, no doubt, looking at alternative avenues, the possibilities of not just the use of remitter, but to allow the comfort of, everybody now does mobile banking. I'm sure it should not be too difficult if one were to sit down and make payments from a mobile phone, from an internet banking system and things like that. So we are also looking into that based on the kind of complaints we're getting. Of course, I've had questions posed at me that despite the fact that we allow for virtual hearing, we have not accommodated hearing through telephony. That for now is an oversight. We are going to look into it and build it in accordingly. But like I said, The critical factor is, how do we cut trial time? How do we speed up trial? And how do we reduce the interface of human beings coming to the court? If you really can do the court business in the comfort of your office, I don't see any reason why you should travel all the way from your office to a courtroom just so that you can have 5-10 minutes and be on your way. Of course, since the practice directions came out, I've read of several comments, and some of which are issues that I'm sure panelists are going to take up today. Whether or not what we are doing is valid, it's legal, it's constitutional. The only thing I can say is that even within today's structure of the physical court sitting, what is called the open court system, the truth of the matter is we have had so much limitations as to who can come physically to a court that I do not see what is more public than a virtual hearing. I'm sure by the end of today's session, if we take the statistics of those who joined us in the discussion, either as participants or as panelists or as listeners, you would find out that the number would far outweigh if we were to have gone to a physical hall to do this same discussion. Just so that we can have a general discussion, I would want to stop at this point and urge that I give room to panelists to be able to air views on what is before us. Thank you.
Thank you, my lord. The President of the National Industrial Court of Nigeria, my Lord Honorable Justice B.B. Kanyi. Thank you so much, sir. At this point, may I please invite to the microphone for his goodwill message, the Solicitor General of the Federation and Permanent Secretary, Federal Minister of Justice, Mr. Dayo Akpata, SAN. Mr. Solicitor General, sir, please unmute your mic, sir. Mr. Solicitor General, your mic is muted. Could you please unmute your mic?
Okay, can you hear me now?
Thank you, sir. Yes, sir, we can hear you, sir. Mr. Solicitor General, your mic is muted, sir. No, no, sir, we can hear you, Mr. Solicitor General.
Can I go ahead now?
Yes, sir, we can hear you, sir. Thank you.
Okay, my Lord, the President of National Industrial Court, permit me to stand on the existing protocol as identified by the NBA chair. Let me bring the greetings of the Honorable Attorney General, and let me also say that I'm highly honored to be part of this commendable initiative of the Committee on Legal Practice on the National Industrial Court of Nigeria Practice Direction and Guidelines for the court sittings. Essentially, this is a milestone in our collective quest to keep the wheels of justice rolling, even amidst the COVID-19 pandemic and all that it portends. And as stated by my Lord in his keynote address, beyond the pandemic is our collective quest to scale up our legal practices to be in tune with international best practices. I am very sure that this meeting would provide a veritable platform for conversation relating to the NIC practice direction, its practical application and workability. Furthermore, the platform will also avail us the opportunity to discuss the constitutional issues relating to the validity of the process. As you are aware that the Federal Ministry of Justice, arguably the largest chamber in Nigeria, and being the office of the Chief Law Officer, should by necessary implication be part of this movement. And in discussing this movement, you will recall on the 20th of April, the Honorable Attorney General made a press release on plans for post-COVID-19 justice system in Nigeria. And he strongly advocated for a shift to adjust the judicial process to be responsive to our current realities and make for recovery of lost ground due to the effects of the pandemic. He also highlighted and suggested the deployment of ICT facility in the judicial process, especially for fast-tracking cases, as a critical measure for effectively dealing with our current emerging challenges. I think this is another opportunity for us to sit down together and scale up the ICT process in our the current challenges that we're facing. And he also advocated for the need for greater cooperation among the stakeholders in justice sector. And if I may just quickly bring it to the knowledge of this August gathering, is that the Attorney General also inaugurated a committee and which to assess and identify the challenges and the impact of the pandemic on the entire justice system and make appropriate recommendations on the immediate, the medium, and the long-term measures for addressing the challenges in the country. And the membership is drawn from the various sectors of the stakeholder, including the judiciary, the NDLA, the Nigerian Correctional Services, and the Nigerian Police, among others. And the work of the committee itself is to assess the ICT infrastructure in the Ministry of Justice, the deployment of virtual studio rooms in the Ministry for Virtual Hearing and Teleconferencing, and also deployment of case management platform and the engagement with the National Assembly on relevant constitutional amendments to support the practice direction, which might be one of the issues to be addressed today. Also, the assessment of the ICT infrastructure in the correctional services. You will recall that the issue of awaiting trial has been a bit disturbing to all of us, and we're looking at the situation of having the ICT in the correctional services. We're having some serious discussion with the Ministry of Internal Affairs and the Correctional Services. Also, we are reviewing the legal policy and framework to support the administration of justice within the national policy of 2017. And my Lord, presently, I think in a week to today, where we'll be having meetings with the 36 attorneys general, and the essence of this meeting is also to ensure that it is to complement the effort of the judiciary in ensuring that Nigeria as a corporate entity meets up with the standard which is required in the administration of justice. And also we are engaging the National Assembly on other areas. So without wasting the time, these are the issues which we consider in our own, in the Ministry of Justice, in the executive arm, to ensure to complement the effort of the judiciary. And we want to welcome all any assistance or in the derivation, in the conversation that will also assist us in this, our quest. Thank you very, very much.
Thank you, Mr. Solicitor General of the Federation. Please convey our regards to the Honorable Attorney General of the Federation. His greetings are well received, and thank you for delivering same this afternoon. My Lord, the President of the National Industrial Court of Nigeria, my Lord, Honorable Justice O.A. Obaseki Osage, and all other justices of the National Industrial Court of Nigeria here present, distinguished senior advocates of Nigeria here present, colleagues, erudite panelists, ladies and gentlemen, good afternoon. My name is Mimi Ayua, and I'll be moderating the session this afternoon. But before we begin discussions proper, permit me to lay down the ground rules for this afternoon. At the bottom of your devices, you're going to find the Zoom app toolbox, and we have enabled two boxes, particularly the question and answer box and the chat box for participants to send in their questions and observations and comments. We employ all participants to begin to send in their questions, and at the end of discussions, we will take them as appropriate. For our discussants this afternoon, if there is a box, the raise your hand icon that has been enabled. If you do find a need to support an opinion or make another comment in support of a particular opinion, you could do it by raising your hand, and then we'll give you an opportunity to support a particular position as canvassed by your co-panelists. Distinguished panelists, my Lord, the Honorable Justice B.B. Kanye, all other justices here present, may I seek my Lord's permission to proceed into discussions properly this afternoon. My first discussant will be my Lord Honorable Justice O.A. Obasike Osage, who doubles as the chairman, the Rules Committee of the National Industrial Court of Nigeria. My Lord, this afternoon we would expect you to speak to us on the significant highlights of some important provisions of the practice directions. Since you were involved in drafting these practice directions, we want to understand some considerations and reasons behind some of the innovations contained in this practice direction. Over to you, my Lord.
Thank you very much. I hope you can hear me.
Yes, my Lord, we can hear you.
Yes. My Lord, the President of the National Industrial Court, permit me to stand on the existing protocols. My task this afternoon is to discuss those significant areas in the practice directions. And because of the time constraints, I will be dealing with one in particular, and that is the trial on record procedure. It is not particularly a new procedure for the National Industrial Court. It has always been there, but we find that it is rarely used. Before the third alteration to the Constitution, it was used quite significantly by Council. And because of the use, we were able to dispose of matters within 3 to 9 months. And after the third alteration, we realized that quite a number of counsel, perhaps not understanding the procedure of the trial on record, were a bit reluctant to use it. So it is a procedure that is with us. And I am using this opportunity to encourage counsel at this time to try to use the trial on record procedure, which is what I'm going to be talking about. The trial on record procedure is not for all matters. You cannot use it for matters where, for example, where you are alleging discrimination, where you are alleging sexual harassment, where you are, where it's an injury matter, because it is a procedure that deals only with the documents. So it is strictly one that is based on documentary evidence. The importance and the relevance of this procedure at this time of COVID is because it enables parties to quickly dispose of the matters, particularly when at the back of our minds, we do not know how long this COVID period is going to last for. And also because we know that for labor matters, it is extremely important for the parties who are involved, the worker, to get a judgment, whether it is a good judgment or whether it is a bad judgment, speedily. And this procedure is what is going to enable parties to obtain that speedy decision. And how does it work? It works where you file your processes. You file the process, and when you file your process, of course, you know you're filing your process together with your documents. The documents must be marked. That is one of the important aspects, so as to speeden the trial. The documents must be marked. And in marking the documents, you must link specific parts of the documents that you are relying on to the pleadings and the statement on oath, so that there's no difficulty for either the counsel or for the judge who is handling that matter. Then the documents that are filed together with the originating processes of both parties. Of course, there's always a schedule. We see that counsel most of the time do not attach a schedule. The schedule of documents, you must state which document you are objecting to at the point of filing, so that at the point of filing, you have marked your documents, you have stated on your schedule, I am objecting to this document, I am not objecting to that document. So the other party is aware. And where the objection is very serious, what you must do is that you must file the original copy of that document, the physical copy, to the court 5 days, at least 5 days before the hearing. And so before the court, you have the documents, claimant's documents, the documents of the respondents. And then, of course, we are ready to go. But then, counsel must agree on the documents, because the parties are not going to be in court. So those documents are so vital. It is so important for counsel to agree on the documents. And once counsel have agreed on the documents, then we are ready to go. Some people would ask, how does that work in a trial? And we say that once counsel have agreed on the documents, together, those documents can be admitted from the bar, because there's no dispute. And once there's an agreement on the documents and the documents are admitted, the next process is for counsel to adopt their final addresses. So in the final addresses, everything you want to say will be included, or you should include everything in the final address. So the day the matter is called up for hearing, the processes are there, the documents are there, you have linked the documents to the pleadings, to the statement on oath. Your final addresses are before the court, and you just come, you adopt the final addresses, and the next thing is judgment. So within the structure of the trial within the structure of the trial on record, the trial process is already included, because in linking the documents to the pleadings and your statement on oath, you would have stated, for example, in the statement on oath, I only have a photocopy of this document I am relying on. You would have laid the foundation. And so there's no time to waste. Everything is before the courts. Everything is before both parties, and then you go on and argue. So you eliminate all the time of bringing in the party from wherever and so on and so forth. And within 3, 4, 5 months, you get your judgment. So this is one of the advantages, and which we are encouraging litigants and counsel particularly at this time to use this process. It saves time. It's a process that does not necessitate parties coming to court, which we are trying to avoid as much as possible. And then, of course, it ensures that judgment is delivered within a very short time. I will stop here for now. Thank you very much.
Thank you, my Lord. Honorable Justice O.A. Obaseki Osagi. Thank you for throwing more light on the important provisions of the practice direction. To show you how important this session is to legal practitioners, we have over 250 participants at the moment. And we, of course, we're expecting more, because we have close to 500 registered participants. Thank you very much. May I, at this point, reiterate the importance of speaking within the time allotted. As a speaker, we'll have 10 minutes, and at 7 minutes into your time, we'll be showing you a yellow background, which means that's a yellow card for you to begin to round up. round up rather, I beg your 10 minutes, exactly 10 minutes, we will give you the red card. And we'll plead with you that you oblige us when you see these notices. Thank you very much. Now, our second speaker is an erudite, distinguished senior advocate of Nigeria, and he'll be speaking on the perspective on the workability of the rules and the significant innovations and limitations created as regards the guidelines to court sitting. This is no other than Mr. I.O. Olorundare, SAN. The next senior advocate of Nigeria, sir. Over to you, please.
Good afternoon, everyone. My Lord, the President, the presiding Justice of the Industrial Court, Lagos.
Leonard Senior Advocate.
Yes.
Sorry, sir. There's this echo from your background, and it's
Yeah,
affecting output.
That is what I'm trying to avoid.
Okay, thank you very much, sir. Over to you. Continue, please.
Okay. The learned senior advocates on the panel, and my learned friends and the members of the public who are watching us all over the world, I greet all of you. The perspective and the workability of these new rules, or the statement just made by my Lord, the President of the Industrial Court, is a noble thing that we have all been itching for, that we should have this type of a thing for us to work in Nigeria, because some of us that have been participating abroad in most of these things, we have been seeing that virtual hearing is the in thing now, and it should be done in Nigeria. And I'm so glad that maybe because of this pandemic now, we now have a good aspect of this matter, so that we can now be relating with ourselves either by video conferencing or Skype, like it's being done even in some arbitration. That I hope I'm being heard there. Hello? Hello?
Yes, my Lord, we can hear you, sir.
Okay. Yeah. So, like it's being done in most arbitration matters these days, you are on Skype, you are on Zoom, you are on video conferencing, and that gladdens my heart. Now, the innovation that has been brought by this guideline and practice direction is so noble, like my Lord has said, the President of the Industrial Court. All I'm just pleading, and which I've experienced of recent in a specialized court, is that like it is provided for in Order 6, Rules 6 of the new practice direction. It is very important that most of the things that we needed in the court are available, because if these things are not available, we will always just be laboring in vain. But like it is so stated specifically, like paragraph 7, subparagraph 9, where it is stated that fast speed, pervasive and reliable internet connectivity. It is so important that we have internet connectivity. And with the experience we have in Nigeria, can we have these things to be very reliable for us? These are the workability. How would this thing be able to be working for us in Nigeria, where we have epileptic power supply? Because most of these things depend on power. When there is no power, you know the cost that is costing the people that are connecting us to this internet, to this Skype and all these things that we needed to be using in court. But again, we have to look at the verbatim recording. Like I said, in a specialized court that I attended of recent, maybe because it's just a sole court in that place, they made every of these things to be available. And I was wondering that in these people can make available this type of a thing in Nigeria. And I was so pleased about it. Then again, as a practitioner, I've experienced it, and I know that people will argue it later. My colleagues will argue it. I've been looking at the constitutionality of this practice direction and guideline, but maybe my other colleagues are yet to advert their mind to the provision of section 36 section 4 paragraph A. In that paragraph A, it said, a court or such a tribunal may exclude from its proceedings persons other than the parties thereto or their legal practitioners in the interest of defense, public safety, public order, public morality. Now we have a problem now, and that is what has brought this practice direction and guideline. Can we say in all honesty that we are not having public safety problem as a result of this pandemic that has broken out? So these rules, to me, I believe has come at a very auspicious time. And like my Lord, the President has referred to it severally in the practice direction. It is to make access possible for the public. Now, public here, we can see that the public can be entertained like what we have when you want to do the swearing in of judges or new senior advocates at the Supreme Court. There is a place whereby you have public gallery where people are watching what is going on in the main hall. Like in the law school of the Hold, when we were in Lagos, some people were in television room and they were following the lectures that were being delivered that time. Now, the same thing can happen now, so that in all courts, they can make it available whereby people can be watching while the parties and their counsel are in the main court hall in order to observe social distancing. And then apart from that one, I do not see anything that makes it, unconstitutional in this respect. So I must commend the way the president of the industrial court has put this thing together with their lordship at the industrial court. It gladdens my heart that some of us that have been itching for something like this, a new dawn is being enacted in Nigeria for us. And going through it, when we follow it letter by letter, we will discover that we who are the practitioners are even best served with this guideline and practice direction of my Lord. I believe that it's going to be a workable one. My learned brothers of the inner Sikh, I've looked at some of the cases that have been sent all around in the social media, but I will want us to look much closely again at that section 36, subsection 4, subsection A of the Constitution to see that what is being done here is not something that is unconstitutional, though it may need some fine-tuning by the legislature. But for now, any judgment that is rendered as a result of this pandemic, because the practice direction left nobody in doubt that it is a response to COVID-19. and thereafter, which could be adopted. Because when you start something, you keep on perfecting it until you become perfect in it. Even the courts that we are using now, they started from somewhere, and they started perfecting it until, and it's not even perfect. That's why we keep on changing the rules of court every now and then in order to meet the time that we are currently in, so that things are not obsolete or we are not behind time, like what Lord Denny advised us to do in Packer and Packer, that we should do new things, we should be innovative. And I think I buy into the innovation that is this practice direction and guideline, and I commend their lordship and all other participants. Thank you very much. If I'm not out of my time yet, I would have loved to. Thank you very much.
Thank you very much, Leonard, Senior Advocate of Nigeria, Mr. I.O. Olorundare. Thank you so much. May I, at this point, apologize that I referred to you as Milord a few minutes ago. I apologize. Distinguished participants, I have just been informed that we have all of justices of the National Industrial Court of Nigeria on this webinar with us this afternoon. May I, with the kind permission of my Lord, the President of the National Industrial Court of Nigeria, and on behalf of the Chairman of the Committee on Legal Practice and the Chairman of the NBA Abuja Branch Unity Bar, welcome you all to this webinar, and thank you for being with us this afternoon. Distinguished participants, may I at this point move on to our next speaker, who will be speaking to us on the utility of issuing practice directions during COVID-19 pandemic and beyond. Our speaker is no other than Professor Peter Akpe, SAN. Leonard Senior Advocate on the erudite. Prof, please, over to you this afternoon.
Thank you. Thank you, distinguished participants. Good afternoon to the President of the Court and my colleagues, Leonard Senior Advocates of Nigeria, participating, and those listening. Let me adopt the order of protocol already set out for this meeting. It's my pleasure to speak to you this afternoon on the utility of issuing COVID-19 guidelines during the pandemic and beyond. I consider it very important to talk about this because having rules and the utility of the rules are a different thing. So for me, I want to look at what we are doing today and to be able to say that, yes, there's some public good in issuing this good. And in this regard, I start from the very basic by asking some questions, which I will try to provide answers to in this discussion. And I've basically organized my presentation into three main topics or questions, if you like. One, why issue practice directions? Two, what are the benefits that accrue from such practice directions? And finally, are there takeaways that we will get from the issuing of such rules? So by way of answering the first question, which is why issue practice directions, I've noted that COVID-19 has fostered a novel operating environment for the justice sector in Nigeria generally, and that we are no longer doing those things that we were used to doing before. It has affected all aspects of our human endeavor, our health, our relationships, and so on. And so there's a need for us to begin to adjust to the new operating environment that COVID-19 has foisted on the country generally. Now, many jurisdictions, including Nigeria, have tried to adjust to this situation by responding to the various disruptions that COVID-19 has created, particularly in the management of justice delivery generally. So in the midst of all these disruptions, there's the overriding consideration, which is that while all of this is going on, we must ensure that there's access to justice. And that much is reflected in the rules as one of the objectives, to ensure that there's access to justice. Because in spite of the pandemic, we still have contractual obligations continuing. We have rights of people. Some have been complaining of rights violation and so on. All of this requires some dispute resolution mechanism to be put in place, either to allow parties to ventilate their disputes or to give the courts an opportunity to be able to resolve them. And so practice directions enable heads of courts to make provisions for new situations and circumstances such as COVID-19, a pandemic, and that are not already covered by existing rules. So that is one of the practical utility of having to issue practice directions. Also, I look at it from the point of view of benefits by saying that practice directions actually impose new ethos. They impose new ethos, new practice, and new procedure, both for judges, court administrators, court users, litigants, and lawyers. And this is necessary for purpose of ensuring the safety and well-being of all stakeholders in the justice sector. My Lord Justice Kayim already highlighted the benefits of the various guidelines put in place, particularly as it relates to sanitation, for purposes of protecting the health and safety of people generally. Now, if this ethos, new way of doing things are not actually put together, it probably be difficult for us to ensure that the right results or outcomes, we are able to benefit from that. Now, also, practice directions signpost the new situations, warranting innovations and processes designed to respond to those situations. My Lord Justice Obaseki Osage has already highlighted some of the very innovative provisions that have been put in place to respond to the COVID-19 pandemic, as we're talking about generally. But one thing that is very important, and this is one of the very important utility of having practice direction, is that it ensures that there's uniform practice. Now, without the practice directions, lawyers, judges, different court users, and so will be responding differently to the situation that we find ourselves. But with these directions, there's a uniform practice across board. And therefore, there's predictability. We know what we expect from court 1, court 2, court 3 in terms of the discharging of their roles or their judicial duties during this pandemic. Without practice directions, lawyers, some will choose to file their processes, for instance, online. Others will choose to do other things. And at the end of the day, there will be chaos in the system. So it has helped us one way or the other to ensure that there's uniformity and, of course, predictability. Another very important benefit, and if you like, advantage of having rules has been the way these rules have accelerated the integration and use of technology in the justice sector. Now, my Lord Justice Kayim had already alluded to this fact that certain courts were ahead of others in trying to put it together in ICT infrastructure to ensure that we realize some of these things. But COVID-19 has come with its own peculiarities and has created an enabling environment for the use of technology to be accelerated across board. So it's no longer a case of one court lagging behind. Almost all the courts in this country are responding in a similar fashion. And so it's something that we consider to be a benefit that has arisen from the rules of court. Because if those rules were not in place, or those practice directions were not in place, for instance, then the responses would not be in this manner. And in fact, we will not be able to achieve that fast-tracked use of technology that we are all urging during this period. And so I then say to myself that since these benefits are there and they ensure that there's uniform practice across the board, there must be takeaways that we can get from this process. And in this regard, I have identified some major takeaways that we can take from it. The first one is that the reality is that we cannot reverse the changes that COVID-19 pandemic has foisted on the justice sector. We have made some quantum leap based on the effect of COVID-19, and I think those quantum leap are not reversible. So we must change the way we do things, particularly. And I give an example. now the idea that my colleagues, senior advocates, sometimes appear in court with all their office. A senior advocate leading 10, 15 people, we have to change because the rules now will not allow for that number of people to be in court. We are afraid of large gatherings and so on and so on. So that would have to change. Secondly, the issue of ensuring that before now you will hear people say that I'm not used to computer. I don't want to use computer. That will no longer be attainable today because for you to function under this environment, the use of technology will become very, very important. So it has become a permanent feature. Now, even post-COVID-19, I believe that these structures that have been put in place, these processes and rules would endure. And therefore, we can only do more in terms of improving on what we have, rather than to go back to our old ways of doing it. Now, it also has implications for us generally in terms of reskilling ourselves and equipping ourselves so that to be able to perform effectively. Those of us who were not IT compliant before, or IT savvy, I should say before, now this creates an opportunity for us to retool and equip and retrain ourselves in such a way that we can function effectively. My learned brother Arun Gade already made allusion to the fact that this massive deployment of technology itself comes with an initial high cost. Most of the costs that were not with the initial infrastructure in place, we have to acquire them and acquire them within a very short time. This comes at a very high cost, but I do believe that in the long run, it will be cost saving and time saving. So for the judge as well, it provides an opportunity for us to deliver justice within a shorter period of time, as the rules now would ensure that judges are able to take their rulings and in fact manage their case and in such a way that they are able to achieve the objective. So by and large, the pandemic has its disruptions, but on the whole, it has also brought about some immense benefits for us, as we can see in the rules. I thank you very much for your attention.
Thank you very much, erudite Professor Peter Akwe, SAN. Distinguished colleagues, may I, at this point, move on straight to the next panelist. Now, the question is, there is likely to be issues, or there are likely to be issues, that will emanate from these practice directions and the need for constitutional amendment. Of course, already we have a question regarding constitutional amendment, to accommodate virtual hearing. Now, the question is, there have also been arguments for and against the validity of virtual hearings under our jurisprudence. Now, one school of thought says that the provisions of Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, is wide enough to accommodate the proposed virtual hearing. While the other school of thought believes that the Constitution does not allow for virtual hearing, and as such, cannot accommodate the said proposal, except with an amendment. Now, following the above, what is the constitutionality of the provision for virtual hearing in the practice direction? May I now invite to the microphone to help us tackle this question, Mr. Joshua Olukayode Olatoke, Senior Advocate of Nigeria. The next Senior Advocate, please.
The President of the National Industrial Court of Nigeria, Honorable Justice B.B. Kanyip, may I be permitted to stand on existing protocol. I must start by appreciating the organizers of this program for giving me the honor to take part in this program, which is a watershed. And what is more, the program comes at a very critical period of our history, and I'm proud to be part of this program. And I'm to consider the two sides of the argument in respect of the constitutionality of the virtual proceedings. And that is Section 336, subsection 3 and 4 of 1999 Constitution as amended. I will start with the status quo, because we are used to the decisions of the court in respect of Section 36, subsection 3 and 4 And just like my learned senior brother said, I owe Olorundare SCN just a few minutes ago that some of our colleagues, they have argued that because virtual proceeding will not amount to sitting of the court in public, in that wise, it will be unconstitutional. I'm going to start from there. Because section 36 subsection 3 provides that courts and tribunal proceeding must be held in public. And section 36 subsection 4A provides that courts and tribunal may exclude from its proceeding persons other than parties to the case or their legal practitioners in the interest of defense, public safety, public order, public morality, welfare of persons yet to attain 18 years of age. And this provides an obligation. Section 36 subsection 4B also provides for obligation of the court or tribunal to honor the satisfactory request of a minister or commissioner that it will be in the interest, public interest, for a matter to be heard in camera. The issue now is whether virtual proceedings could be said to be unconstitutional. As I said earlier, I'm going to start from the status quo. What is meant by public? The word public. Black Law Dictionary 9th edition define public as being open, available to all. And Webster said define it as open to all, the same thing. Then it remains to be seen how hearing of a court case through Zoom, Skype, Instagram, Microsoft Teams, webinar, etc. could be said to be a public sitting. Most of the arguments have been that the requirement of public hearing and determination of cases in Nigeria is mandatory, as the operative word in the Constitution is the use of the word shall, which means it is compulsory and mandatory. And most of my learned friends, they have cited the cases of Debo against the state, where the court held that because the court sat in chambers, the proceeding was held to be a nullity, because the chambers of a court is not synonymous to a public place. And also the case of Nigeria Arab Bank Limited against Barry Engineering, where the Supreme Court set aside the judgment, holding that the delivery of judgment in the judge chambers was an irregularity which borders on legality of the whole proceeding. The case of Chukwuka against COP, the court held that hotel was not a public place because since the landlord was time person to leave his premises and public could not insist of any right of entry. In Salawu against Adiza, the Court of Appeal held that the word public is an adjective affecting all the people and the whole nation, and said that public also means open, unrestricted, known, unconcealed, and in public means everyone. My learned senior brother, Chief Awumolo, recently noted that about 25% to 40% of Nigerians owns a smartphone, thus meaning that 60 to 75% of Nigeria cannot participate in such a remote proceeding. Hence, virtual proceeding cannot be said to be in compliance with the constitutional provision. In another breath, it was also argued that remote and virtual hearing are not accessible to everyone due to login requirements, internet and phone conditions. Therefore, the foregoing have shown that proceedings held virtually through Skype, Zoom, etc., cannot be said to have been held in public, and it will be unconstitutional because public place means any place which the public or any section of the public has access on payment or otherwise as of right or by virtue of express or implied permission. I will again now consider the other side of the coin, that virtual proceeding as contained in the Nigeria National Industrial Court practice direction is constitutional. It is not in dispute that Nigeria is in difficult time, which is evidenced by the COVID-19 pandemic and the resultant lockdown on public gathering, including the cost sessions pursuant to Quarantine Act Cap Q2 LFN 2004, which has necessitated the call for the Nigerian justice delivery system sector to consider the option of virtual hearing to deal with the urgent matter. Though Section 36 of Section 3 and 4 of the Constitution as amended provide for courts and tribunal to sit in public, but Section 36 of Section 4A allows the court to exclude any other person from his sitting apart from the parties and their legal practitioner in the interest of defense, public safety, public order, etc. A public safety is not only for safety against invasion by foreign enemy. You can see the case of R versus Governor of Warwood Scrub, reported in 1922 KB 305. Therefore, public safety here also includes the pandemic that we are in now, the pandemic period. Therefore, a court can exclude any other person except the parties and their legal practitioner. This therefore has limited what is referred to as the public. It means where the court officials, the parties, and their counsels are present when public safety is required, as in the present time. The court will be regarded as having sat in public. In the case cited in support of the contention that the virtual proceeding is unconstitutional, the exception of public safety was never considered in any of those cases. And I submit most humbly that if those decisions were to have happened now, the court would not have decided the same way. The decision would have been different, and the exception of public safety would have called for consideration. And I also want to rely on the case of Odua Investment Company Limited against Alabi, which urged the court to be very mindful of numerous cases cited before it, without considering the facts, whether the facts are similar and the laws are applicable. Because in those cases relied upon on the issue of unconstitutionality, the Section 36 of Section 4A was never considered. Then I want to also say that I must also add that the house of a judge can be regarded as a public place for purpose of virtual proceeding in matter. We do not require calling of evidence, as the practice direction provides, that yes, it's anywhere with the leave of the president of the National Industrial Court. In the case of Jewel and Taylor, it was said that a private house in which a sale of a public auction is being held is a public place. And also, in the case of R&K, it was said that the fact that payment or permission is required before access do not obviate the fact that a place is a public place. See also the case of Glim and Simmons. So all these cases goes to show that the fact that you have to pay for virtual proceeding through Skype and all those things, they will not obviate the fact that the proceeding is not a public proceeding. Can we say paragraph 7 of the practice direction has contravened section 3 and 4 of the Constitution and even section 266 of AJA? My submission is no. A careful perusal of paragraph 7, 1 to 7 of the practice direction will not render the virtual proceeding unconstitutional, because it has not removed the accessibility of the parties to the proceeding. Though I know that paragraph 7(8)(b), which allows the court to conduct sitting in chambers and wherever the court sits may be the problem. What is more, paragraph 7(8)(d) contradicts paragraph 11(2) of the same practice direction. In paragraph 7(8)(d), it was provided that yes, the court can sit in chambers or anywhere. But in paragraph 11(2), of the same practice direction, it was provided that the leave of the president of the National Industrial Court is required. So I would suggest that these two provisions be looked into. So if we want to contend that because we are not present before the court physically, the right of a party has been infringed, this cannot be a breach of right to fair hearing, with due respect. Let's say, for instance, the decision of the court in the case of 7-Up Busing Company against Abiola, where only one of the parties will be before the court. Even if you are in the court, you cannot be heard. Supreme Court has settled that you cannot complain of breach of fair hearing. And it has been our contention as legal practitioners too, that judges can even grant Mareva injunction or any injunction in an urgent matter, even from his bedroom. So at that time, we are making those submissions and the court agreed with us. Are we not saying that the sitting of the court anywhere is constitutional once justice of the case is done? So the courts have established over time that they have power to grant all this injunction in our favor. So in the same way, the court will also have the right to sit, provided that they are not taking evidence where the minor of the witnesses ought to be studied by the court, or you need to cross-examine the witness. So this is the reason why I would want to agree with those that contended that the practice direction and virtual proceeding therein is constitutional. And in view of the fact that the argument is plausible both ways, and in any event, it is better to hear on the side of caution and ensure an amendment of the Constitution so as to avoid the difficult situation that happened as per the recent decision of Supreme Court in the appeal of Uzo Kalu, amending the Constitution of Federal Republic of Nigeria to ensure the room for virtual and remote proceeding would obviate and cater for the future bottleneck and technical issues that could arise in future. Because if we do my submission that it's constitutional, but we will not know what will be the decision of my Lord when this kind of matter comes before them. So to stay on the side of caution is better that we allow an amendment. And that is why I want to subscribe to the move by the Senate of the Federal Republic of Nigeria considering the bill titled 1999 Constitution of Federal Republic of Nigeria, Bill 2020, sponsored by Senator Michael Opeyemi Bamidele, wherein they suggested the amendment to Section 36(3) and Section 36(4) of the Constitution of Federal Republic of Nigeria. So, sorry.
Thank you,
Hello?
Leonard Senior Advocate of Nigeria, sir. It's 10 minutes into your time, but let me just take you up a little bit on some things you have said. Now you have, in the course of your discussion, you had mentioned Section 36, sub 4, paragraph A.
Yes.
Now
Yes.
I have here that that particular paragraph deals solely with criminal matters only. What are your comments on that?
Section 33, subsection
Sub 4.
36,
Section
4A.
36, sub 4A. Yes, yes, Senior Advocate of Nigeria.
Yes. Just a minute. 4A. Yeah. Thank you. The subsection 4A of say you may exclude a court or tribunal may exclude from its proceeding persons other than parties thereto or their legal practitioner in the interest of defense. This will not, the fact that that section applies to criminal matter will not affect the provision of the practice direction, because the practice direction applicability It's also limited to cases where the presence of the parties is not compulsory. If you look at the provision of the practice direction. So it's not of general application. And the practice direction also provides that where you need the presence of the witnesses, the cross-examination, there will be, it also provides for physical presence of the parties. So it will still not be unconstitutional.
Thank you very much, Leonard, Senior Advocate of Nigeria. Milord, the President of the National Industrial Court of Nigeria, Milord Honorable Justice B.B. Kayib, permit me at this point to draw your attention to the submissions before you made by the Leonard Senior Advocate of Nigeria. Incidentally, he spoke on both sides. He presented arguments for and against the validity of virtual hearing under our jurisprudence. Milo, I do not know if at this point I may seek your indulgence, your kind permission to allow you make some comments with regards to that, assuming it comes before you, sir. Or do I allow you speak at the end with regards to these particular submissions before you, sir?
I'll prefer to talk at the end.
Most grateful, Milord. Most grateful. We appreciate, sir. May I, at this juncture, proceed to the next speaker, who will be speaking on the constitutionality of the provisions of the practice directions and its workability. For speaking on this particular question, Ofonze Amuchiezi, Senior Advocate of Nigeria. Over to you, Prof.
Good afternoon. Can you hear me, Mimi?
Yes, Prof. Good afternoon, sir.
Good afternoon, my Lord, the President, judges of National Industrial Court, my colleagues and participants. Well, I think I might just adopt what my learned brother have said. Mr. Latake has covered the field. But basically, I am in support of the constitutionality of the practice directions. But let me just start by saying that I think we do not need to go back to amend the Constitution on every single matter that arises. And otherwise, at this rate, we will end up having a very bulky Constitution. I was privileged to work at the Senate Committee, lead consultant Senate Committee on Constitutional Review for 8 years. And I can tell you that a constitutional amendment, like we all know, is a very cumbersome process. I mean, it takes quite a lot of time, a lot of money. But besides that, back to what we are concerned with. The key question is, do virtual proceedings constitute, are they unconstitutional, or do they constitute public sitting for the purpose of Section 36(3) of the Constitution? And I'm going to refer to the case of Kosi Benu and others against Alimi, which was eloquently cited by my learned brother Silk, Kemi Feniro, in his article on Tuesday, where Mohammed JCA said, and I quote, "It is my firm and considered view that a place qualifies under Section 36(3) of the Constitution to be called public if it is outrightly accessible and not so accessible on the basis of the permission or consent of the judge." So the question is, do virtual proceedings meet this criteria? And my answer is yes. By virtue of paragraph 7, subparagraph 7 and 13 of the practice directions, once the link is made accessible to the public, of course, we can all access the National Industrial Court website. And contrary to what some of our colleagues have said, I am sure that well over 80% of Nigerians have access to smartphones. That's why you can see traders, you can see businessmen, you can see mechanics, name them. Everyone puts up pictures online. They're all on social media. So I don't think that should be a problem. The practice direction on virtual sitting, like I said, in paragraph 7, subsection 7, and paragraph 7, subsection 13, provides that the court will make the link available on its website. And the website is free for everyone to access. Indeed, like my Lord the President said earlier on when he introduced this session, virtual sittings actually fulfill the intention of Section 36(3) more than even physical sittings. From what I can see on the screen, there are 245 participants present in this webinar. And I can bet you that you can't get this kind of number if you are to have this in in a physical setting. People will be busy going around their businesses. And we also remember that even when we have our courtrooms, how many courtrooms are able to take as many as 245 persons? So the essential requirement is, once a member of the public is desirous and able to attend the court sitting, he should not be prevented from doing so. So once the link is on the website and you're desirous, you can go to the website, get the link, and join the court sittings and follow the court proceedings and hear what is going on. Secondly, my brother Silk and Kenny Finiro has argued, and I support him entirely. I'm going to refer to what he said. He has argued that Section 36(3) does not intend to deal with procedural matters regarding appropriate court procedures. And I agree with that. The Constitution provides, in my view, a framework. And as far as I'm concerned, and in support of what he has said, it is the judge, the heads of court, who will determine how proceedings are to be conducted. Let us not forget that the practice directions would not apply to proceedings whole and entire. For example, going forward, why would I have to go to court to move an ex parte application for extension of hearing? Why would I have to go to court to adopt my written addresses? At the moment, I have an arbitration proceedings going on, and with the consent of the parties, our proceedings are ongoing, are being conducted virtually. In the past, I will have flown from Abuja to the venue of the arbitration the first day for a preliminary meeting, and then flown back to Abuja, and then afterwards we take another 2 or 3 days for hearing. All these at great cost and expense to both the parties and also to the arbitrators. So I think that the most important thing is that so long as the manner in which hearings are to be conducted are left to the discretion of the heads of court. We've heard my Lord the President tell us that every week, following the President's direction, he has to decide what matters can be taken remotely or virtually, and what matters will have to be taken in the physical court. We are just beginning. I understand the challenges of infrastructure, but I do know that at the initial stage, there are matters I understand, I know, that where we'll have to have physical hearings, especially when witnesses have to be cross-examined. But you'll agree with me that in a good number of the matters, we can have at least most, if not all of the proceedings online, especially like my Lord said earlier in the morning, and Justice Obaseko Osage also mentioned, a trial on record where the documents are properly marked. That way, it saves everyone time. It saves us the stress of traveling up and down. So I think that we need to, the courts, in my view, should be more, I would say, proactive in interpreting the Constitution, interpreting the provisions of the Constitution. We cannot continue to amend the Constitution at every single step. I can tell you that before this exercise is over, if you know the cost of constitutional amendments, before this exercise is over, it's going to take at least another 1.5 to 2 years. And at the end of that, what happens if in the next 10, 15 years, something comes up again? Do you go back to amend the Constitution again? I think the framework is settled. And I believe that the Constitution is made for us and not us for the Constitution. And so we should credit our judges with some level of discretion and intelligence to properly interpret the Constitution and ensure that the ends of justice is met. Now, my brother Silk has spoken about Section 36(4)(a), and I want to support him on that. I know people will argue and say, oh, that deals with criminal matters. And the question is there anything wrong if we were to extend that to civil proceedings, where the courts could well decide to, I mean, like we've all said, we're all going through some difficulties now. And it is in the interest of public safety that the process we've commenced at this virtual hearing is sanctioned by our courts. And why I do not think we cannot yet judge for the Supreme Court, if the matter were to come to the Supreme Court, but I believe that the Supreme Court must have also thought it out, the NJC, when it came up with its own practice direction. And I'm not sure that at the end of the day, after all the matters that will be taken virtually by the court, when the matter gets up to the courts, that a decision will be taken that such a provision is unconstitutional. Mind you, we've been told by the WHO that this COVID will be with us for the next 2 or 3 years. And I can tell you again, a constitutional amendment will not be through this year. It's going to take at least another 1.5 or 2 years to conclude. Do we then wait until such is done before we go ahead with virtual court proceedings? So I think, in my view, Section 36.3 is constitutional. It merely provides a framework, and the heads of courts have the powers conferred by the Constitution to decide how to draft the practice directions, which is what my lord did. If you look at the introduction to his practice directions, but the powers conferred on him under the provisions of the Constitution, etc., etc. Thank you.
Thank you very much, Professor Ofonze Amuchia, ZSAN. Practice directions have constitutional backing under Section 36, sub 3. Of course, I also took away from your presentation that the Constitution is made for us and not the other way around. And so we cannot be amending the Constitution at each given time. Thank you very much. May I, at this point, thank my Lord, the Honorable President of the National Industrial Court, for engaging with participants at the Q&A box and the chat box. We appreciate you, sir. Thank you so much. May I also employ distinguished panelists to visit the Q&A box intermittently to see if there are questions there for them to answer them without us having to read them out at the end. Thank you very much. At this point, may I invite Mr. Paul Harris Ogbole, Senior Advocate of Nigeria, to the microphone. He will be speaking on possible innovations that should be included in the practice direction going forward. The next Senior Advocate, sir, over to you, please.
Good afternoon, the Honorable President of the National Industrial Court of Nigeria, my lords, judges and justices of the Industrial Court, learned senior advocates and colleagues. It's a pleasure and honor to be invited to speak to the issue, possible innovations that could be included in the practice directions. But first of all, the current situation we find ourselves with this pandemic, the novel COVID-19 pandemic, has necessitated or given birth to the
Leonard, Senior Advocate of Nigeria, sir. We can't hear you, sir, if you can hear me. Leonard, Senior Advocate of Nigeria, can you hear me,
yes,
sir?
hello.
Very
Yes,
well.
I can
Thank
hear you
very
now.
much. Okay, so you're back now. We lost you at some point there.
Oh, okay. Well, I was saying that the COVID-19 gave birth to, the circumstance under COVID-19 gave birth to activation by virtue of the necessity leading to the current practice direction by the President of the Industrial Court. It is in itself very novel, and it has sought to address issues that bother on the contemporary times. First, technology has come to stay. The whole world has gone technology-wise, and we have remained analog over the years. And what my Lord has done is to ensure that we're able to pace up with the rest of the world, and this pandemic has provided such an opportunity. The current practice direction has covered and anticipated much of the things that are to be covered, bordering both, first of all, on the safety and the health of litigants and citizens alike and lawyers alike who go to court, as well as also advance the course of technology and speed up the pace of justice delivery. So it is a commendable effort. Further innovations that can come alongside this are, first of all, the issue of record taking. As it is today, records in court, hearings are conducted and records are taken manually by judges. Developments in the practice direction can allow for automated record taking, whereby the burden of manually recording proceedings by judges will be obviated. That's one of the areas I think we need to also look at. The other part of it has to do with the issue of the 120 hours. 120 hours for purpose of our own safety when proceedings are filed or brought manually. It is required that the procedurally, and the other counsel brings his electronically. The difference would be that that period of quarantine of 120 hours, what happens? The processes filed electronically would have to wait until the ones that pass through the test of quarantine of the 120 hours have passed that test before they can be processed and addressed. So I think it's also another area we need to look at moving forward. One other area we need to look at is the issue of virtual court. We overview that when courts are set up, that certain designated courts within the court building, certain designated rooms within the court building are designated as virtual courts, so that lawyers who do not have the apparatus or the equipment, the technology for remote court hearing can come to such courts. Members of the public can come there and can be assisted by staff of the court for purpose of remote hearing and taking of proceedings. As time goes on, we envision a situation whereby witnesses can also testify remotely. And when this happens, it will reduce the contact, physical contact, effect of physical contact that will arise from parties and litigants coming from wherever for purposes of recording testimonies. So there are cases where we see, for instance, cases bordering on fraud, and then witnesses have to travel from outside of the country to come into the country, or from different other locations. You'll be confronted with issues of security, issues of visa, issues of other health challenges and all of that. But if remote hearing is enabled, that we can hear proceedings from outside of our jurisdiction and outside of our location, then it will also help for the safety of the individuals, and it can pace up and fasten the proceedings. We envision a situation whereby, as we move on, access to the courts would be made more available so that real time, on time, people can hook on if the URL numbers and the hashtags and all of that are made available in such a way that they can just hook on readily without much ado. Now, on the issue of fair hearing, on the issue of fair hearing, I'm of the view that the current situation, going by the provisions of my learned friends earlier spoke about that, provisions of section 36(4)(a) has actually covered or anticipated the situation whereby this current situation we are in falls within the ambit of public hearing. If proceedings are made online and people have access to them online, that is enough for the public. Because even if you were to come to court, you would come to court, pay your fees to come to court. So when you are in a situation whereby you come to court, have access to court via a fee on the technology device, and it is not restricted to people who have access to it. The only restriction, if I imagine, is restriction based on access to participants, people who are probably going to testify and the council, but where access is not, access as it relates to members of the public, they are allowed to participate, but are muted, just like we are muted at some point in time, and you don't make comments. Then it shows that the provisions of the Constitution are not infringed. We can see that even the courts now are beginning to embrace technology in a way and manner that the recent case of PANDAM services, where service of process can be done via text messages, an acknowledgement via text messages is enough service, and that is an aspect of fair hearing, so that parties are accepted. Therefore, I am of the view that we need to be proactive. We need to be proactive, and the more proactive we are, in line of, and the more proactive we are, because at every point in time, you cannot be amending the Constitution every day or coming out with a practice direction all the time. So what we have currently envisages a futuristic situation already. Moving forward,
Thank you, Leonard Senior, Advocate of Nigeria. Our time is gone already. I apologize. I have to take you off the mic at the moment. Thank you so much for your presentations and possible innovations that should be included in the practice directions. Leonard Senior Advocate. Moving away to justice delivery system, may I invite to the microphone a former Attorney General of Enugu State, Mr. Nduka Ikeyi. Mr. Nduka, I would like to hear your thoughts and your comments on justice delivery system and sustainability post-COVID-19 vis-a-vis the new practice directions. You have 5 minutes.
My Lord, the President of the National Industrial Court, please permit me, as we say in Nigeria, to stand on established protocol. I think a lot has been said. So my contribution is intended to be futuristic, which clearly is dealing with the issues that will come post-COVID. As far as I'm concerned, what we have now is an interim arrangement. However, we thank God that COVID has provided the opportunity for the judiciary in Nigeria to begin the long-awaited innovation in our justice delivery system, which I believe have been hitherto archaic, very inefficient and very wasteful. I'm concerned about the pace and extent of future progress. Like I said, I'm supposed to be talking about how do we consolidate, how do we make progress from what we have today. And the first issue that bothers me really is the role of the NJC, in all this. And the reason I'm saying this is I doubt that the NJC has the power to do what it has done. And then what might happen if the NJC continues to assert its power, which I doubt it has, the power which I doubt it has over this matter, might be that various courts that are supposed to move at different speeds or paces might have to wait to hear from the NJC. I've looked at the Constitution, I've looked at the powers of the NJC. I'm not sure that the powers extend to rulemaking regarding procedural matters, or even matters of substantive law relating to how high courts of states and even the federal high court or the industrial court operate. The second issues I want to deal with are matters that are specific to the present practice directions issued by the Lord the President. And I'll look at three particular provisions in the practice direction. One is paragraph 4.1, which has to do with sealing of processes to be filed electronically. If you look at order 6A of the current NICN rules, you'll see that that order permits e-signature, on documents, and a document should be filed in PDF format. If that is the case, then sealing becomes a problem because the only way I will file a sealed document, to put my seal on a document and file it, is I have to scan that document. And it's going to have implications for speed, it's going to have implications for storage capacity in the courts. So I think we may have to take a look at the requirement for sealing. Maybe we need to start doing electronic sealing, just the way we today have electronic stamp duty practice. We may need to start thinking about electronic sealing so that we don't have to seal documents physically and have to scan them to be able to do electronic filing. The second issue I'd like to deal with has to do with paragraph 4.5 of the practice directions. I mean, going forward, this paragraph has to do with the marking of documents intended to be relied upon in trials. My view is that it should be sufficient if that rule is limited to witness statements and oath, which is evidence. Requiring that we also mark pleadings, as such, might tend to blur the boundary between pleadings and evidence. Because what actually those provisions require is basically that we provide evidence related to the documents we are attending, so that those documents will not be deemed to have been dumped on the courts. So I think it should be sufficient if the additional information is provided in the witness statement and oath, and not in the pleadings. Now, the most what I may call dramatic provision I see in the practice direction is actually the sections paragraph 7, 12, I, and J, which has to do with the number of persons, number of cases that the courts will have to schedule on each day. I mean, I've always told my friends who are judges that we have a very deficient practice in Nigeria, where you invite everybody to the courts by 9 a.m. and people have to sit there 2 to 2 p.m. before their cases are heard. I mean, what a professional sells, what a lawyer sells is knowledge and time. So if a lawyer has to come to court and sit there for 4 hours, only to argue his matter for 30 minutes, is entirely inefficient and wasteful. And what we actually done with that is that we impoverished ourselves, because no client who pays you by the hour will pay you for 4 hours just to go and argue an ex parte motion. So I believe that we need to build on the impetus that the directions, our practice directions have provided in this paragraph 7, 12, I and J, to begin to do proper scheduling. I don't have to come to court by 9 o'clock or by 10 o'clock if I'm not going to be heard until 2 p.m. And we need to move further than that and then do what proper scheduling requires, which is, why do I have to come to court? I'm going to round off very quickly. How do I have to come to court 5 times in a year only to be allowed 2.5 hours, 30 minutes each time? I'm better off if you gave me 2 years, gave me 3 consecutive days in 2 years, and I'll come on those days and I'll do my matter, and the matter is adjourned for judgment. So I think these are issues we need to start looking at, and then with a view to consolidating on building upon what we've seen so far, and then making progress in the future. Let me just say something about infrastructure. People have talked about infrastructure. I think the MBAs in various branches should start thinking about setting up virtual courtrooms for our members who cannot afford this thing. Going forward, this thing is not going just to be by way of ordinary Zoom. We have to have very robust systems that can support these trials. So I think that the MBA and some lawyers who are better opportunity than others should actually start thinking of setting up these virtual courtrooms. So where our other colleagues can come in, pay a token, and then have access to these facilities, and after that they walk away. Thank you very much.
Thank you very much, the former Attorney General Enugu State, Mr. Nduka Ikeyi. I am particularly fascinated with the case spreading. What lawyers sell is knowledge and time. And I think I am fascinated. I am looking forward to seeing, those thoughts implemented in our court system. Moving away, may I at this point invite to the microphone Mr. Folabi Kuti, who would share on the practicability of the practice direction. Mr. Folabi, please, over to you.
A very good afternoon.
Good afternoon, sir.
Okay, first, let me thank the, a very good afternoon, the President of the National Industrial Court, the Honorable Judges of the Industrial Court, learned senior advocates, dear colleagues, and participants who have decided to join us in this public hearing that we're having, not in a small room, in a physical building, but in a room, howbeit in cyberspace, large enough to accommodate well over 300 people, joining in what appears to be a raging issue as to whether justice delivery system should be sustained or continue in the light of what COVID-19 has imposed on us. And without saying much, I think that basically some of my thoughts on starting with the constitutionality or otherwise. And if I might just bite that in a minute. I heard Dr. Latoke, beautiful presentation, even made reference to the fact that the Supreme Court in Oduan Talabi had said that, look, it is the facts of the case that will donate what is the issue or the ratio that comes out of it. And I can't agree more. In fact, I can as much as offer that Uputa JSC in Adegoke Motors and Adesoya was so emphatic on that, look, it is not in all instances that you just throw cases and say that, oh, these are precedent, these are what the Supreme Court has said, or this and all of that. The issue as to whether virtual hearing will come within the scope of the Constitution as to public, I am not in doubt that, one, there's not been any decision, there's not been any set of facts for which the court had to consider virtual hearing and then determine one way or the other. So I do not see any basis for those line of cases, Odibo State, and quite a number of that. So this is what has been defined as public. And in any event, there is a running trend in all those cases. And which seems to suggest that if this present fact were to come up before the Supreme Court, it would be accepted that virtual hearing is public. I mean, there's ingress, there's egress, and the public, to the extent to which if it was a physical hearing, would be admitted or allowed to be in court, they're allowed to be in court. I don't think there's any physical structure that can take 300 people in court as of today. I'm talking about the physical structure. So that, to my mind, is how I would like to sum that up. But having said that, I would equally quickly like to go straight to my intervention in terms of the time constraints. I'm told I have a limited time, and it's perhaps important to highlight the practicability of the practice direction. I mean, as from the way I see it. Indeed, in the wake of the coronavirus pandemic and the far-reaching reverberation effect on everything human, the justice delivery sector, to my mind, can claim to have been the worst hit because the justice delivery system has been ground to a halt. I do not think there's any other arm of government, definitely not the legislature, definitely not the executive, that would say that they've been shut down for over 2 months. Nothing has been happening in our court. So it is in that light that ordinarily innovative, laudable, and progressive ideas are getting the court back in session are welcome. And indeed, if we must scale up work in the justice delivery sector, we must be ready to go with the new normal. We can't be arguing, definitely not in 2020, whether we can perhaps enable justice to be delivered through virtual hearing. And earlier on, the president in his keynote speech had made reference to the fact that this practice direction does not have provision enabling proceeding via telephone. In fact, that was one major thing that I noted and I wanted to address. And thankfully, the president has said that would equally be accommodated. I was going to make reference that as far back as 1985, the English CPR, the White Book, recorded 2 cases in which injunctions were issued over the telephone. 1985, this is 2020. We can't be talking that these are strange times, these are novel, and we're tying it to an interpretation which is, with due respect, is anything but purposive interpretation that a constitution should always at every point in time. So as to the areas that I've spotted on the practice direction that perhaps maybe share thoughts on what can be done about it. Filing of processes, it's been incorporated, cannot be done electronically. And my thought about that is, if it is possible to tweak it further, that filing of processes, except originating process should still be filed physically, physical attendance in court, and for two reasons. Thankfully, Mr. Ikeyi just made reference to the practicability or the impracticability of sealing. I mean, that would probably be thought that I'll just steal from you. But the first two that I had in mind has to do with, number one, originating processes. By the nature, ordinarily, they tend to be bulky documents. Now, technology has its own limitation. You would need to click on all these files and all these papers to go through those documents. That is number one. And you can well imagine a staff handbook, for example, running into 100 pages, and maybe all that is being persuaded or intends to be persuaded before the judge is just a page, maybe page 47 or thereabout. The technology which you still need to run through to be able to get to that and all of that. And that in itself, I mean, medically, it has even been shown that you do not derive from the, that comes from the digital platforms. I mean, the various systems that we use. There's a limit to which we and all of that. So I mean, you'll probably agree with me. Secondly, and more importantly, we're a highly litigious society, and you agree with me that the bulk of our litigation, case law, 80% is actually on procedure. It's largely on procedure. Now, because it tends to be procedural based, and then with lawyers ever ready to argue minutest point to even absorb detail. Despite the position of the industrial court as to the applicability of Sheriff and Civil Process Acts and quite a number of those laws around the issuance and service of processes, we cannot completely shut out the possibility of objections being raised and being taken all the way to the Court of Appeal, that the process was not properly issued, was not properly served. So for whatever it is worth, if it is just to limit it, we may perhaps want to consider limiting just to every other process, but except originating process. Paragraph 5.3 stipulates that when you come to make physical and filing, those processes would be accepted and taken through an alcohol-based sanitizing process, for which they will now be kept separate for minimum of 120 hours. Minimum of 120 hours is about 5 days. Time-sensitive matters, matters for which you urgently require an injunction, I don't think we'll probably have the luxury of 5 days being kept somewhere before it can even be accepted for filing. So my recommendation about that, and I think should be in line with WHO recommendation for sanitizing processes. WHO recommendation is within 2 days. In fact, for certain processes, they've suggested as much as 6 hours. So perhaps the time could be reduced for quarantine of those processes. Paragraph 6.6 on
Thank
service
you,
to
Mr. Falabi. I apologize. Our time is already fast spent. I see the expression there. Okay, maybe you have, let me just give you one minute to round up. Is that okay, sir?
Oh, okay. All right. Paragraph 6.6 talked about service, that service generally it is when it is delivered. Now, I don't think that is the position from two perspectives. Service, and thankfully, as recently as January, Supreme Court made a decision interpreting the provision of the NIPOST Act as to when service is completed. I'm sorry, it is when it is sent. And that is the case of Citibank and the KDHE. But more importantly, even within the context of electronic transaction bill recognizes when it is sent. And in any event, service raises rebuttable presumption. So if anybody wants to contest that he didn't receive and all of that, there are opportunities. And I think Major and Schroeder, Supreme Court decision equally recognizes that and all of that. So that threshold should be minimal, which is the fact that it is been sent and it can be shown. Paragraph 10 on address of witnesses and on adoption of written addresses, that a simple letter can just be done to the court. Perhaps we want to tweak that to equally say that it should be copied to the adverse party. Then telephone and recording, it is important. the way it is now being done in the UK, in the number of the decision is recording would be with the leave of court. And a major decision has recognized that recording may be manipulated or doctored for mischief of all sorts of superimposition. So I know that that is not there. Considering that anybody can join on digital platform and record and use, it should be whatever is being released ultimately as a recorded by the public should be subject to the leave of court. I think I can leave at this.
Thank you very much, Mr. Folabi Kriti. Thank you so much. You have shown industry there, and we appreciate that. Permit me at this point to move straight to the other lady I have on the panel this afternoon. I am aware that I'm aware that litigants and their counsel are responsible for ensuring that they have the facilities stipulated in the practice direction for remote or virtual hearing. I would like your perspective on this provision this afternoon. May I please invite to the microphone Regina Roli Okotiebo. Good afternoon, please. Over to you, ma'am.
Good afternoon, President of the National Industrial Court of Nigeria, Honorable Judges of the National Industrial Court of Nigeria, Senior Advocate of Nigeria, and my learned friend and participants on this platform. There are lots of, let me just start that the National Industrial Court of Nigeria Practice Direction and Guidelines for Court Sitting 2020 is actually a good step in the right direction. I know there are issues that litigants and lawyers have guidelines, and I know the major one that have been a concern to litigant and to lawyer is actually the clause 7.9, which particularly talks about provision for fast speed, pervasive, reliable internet connectivity, end user and hardware devices, desktop, laptop, tablets, smartphones, and electricity power is the city. The most important part actually stated, litigants and their counsel shall be responsible for ensuring that they have the facilities stipulated in paragraph 9. And the major issue that I know there is, we know that National Industrial Court is basically employee and employers court, sort of. And when we talk about this issue of provision of this to enable the responsibility. In fairness, we know that when such costs will arise, the counsel is going to push that to the litigant. And how do you expect an employee who has been out of work for 7 months and wants to institute action for either unlawful termination of his employment to have ability to provide these issues that we're talking about? We're talking about electricity power. We know that's a problem in Nigeria. Even to counsel, as we sit in our offices, we run generator power cuts all the time. But be that as it may be, in my own suggestion as a counsel, it would have been better if there's a provision in these guidelines or in future in the rules of the court, wherein the court can make provision for maybe a room that can be termed as IT room or technology room, since National Industrial Court will have the capacity to make these provisions available to enable litigant and counsel to be in that room. The essence of this practice direction is dispensation, fast dispensation of justice, and also to avoid this interface. If the National Industrial Court could provide a room whereby litigant, counsel can be there, and they have this, maybe they had a particular fee, it would be a lot easier. That is my own view and a take on this issue. And another issue that I know that litigants have issue with that is the issue of the borders on paragraph 712K, which actually talks about evidence being taken and with the overruling Evidence Act that you will not have the possibility foundation. But in all fairness, the National Industrial Court, I think, is the only court in Nigeria by the provision of Section 12(1) of the National Industrial Court Act, which actually makes it possible for judges of the National Industrial Court to, to depart from the Evidence Act in considering admission of documents, which I think with that alone, that is actually taking care of the fear of the council in this matter. And then furthermore, I also know that the guidelines right now is in the right direction. There might be problems about it or issues. There are issues that we could walk through, an issue that could be sorted out. Those are issues that I know that we could sort out within time. And also the major issue also that I know everybody will also know when they talk about technology in Nigeria, we know that the technology in Nigeria is it's poor, if I may use that word. When it comes to information technology, it's very difficult. We have people's system buffering. We have how long it will take you to connect. And those are issues that I think even as a council, I have a problem with. I'm sitting in my office now. I know that a lot of time I've seen maybe we have issue with the sound system. And that will also be an issue that will also face the National Industrial Court in carrying out this issue. But in all fairness to the whole provision,
Hello, Regina, can you hear me, please?
I can hear you. Hello, I can hear you.
We lost you at some point.
Okay.
Okay.
What I just said,
Could you please round up your presentation?
Was I talked about these. So to round up my presentation.
Yes, ma'am. Okay, distinguished panelists, at this point, we are unable to continue because we can hear you. We are hearing muffled. Regina, please. At this point, permit me to proceed. Permit me at this point to proceed, Ms. Regina. I apologize. We can no longer take your conclusions as we can hear you. May I, at this point, invite to the microphone Mr. Audu Anuga, who would be speaking from his own perspective, from all that have been discussed, what do you think? Do you think, rather, that the National Industrial Court of Nigeria is ready for the virtual remote hearing, considering the level of development of technology in Nigeria? Mr. Audu, please.
Yes, the Honorable President of the National Industrial Court, Honorable Justice Obaseki Osage, learned senior advocates of Nigeria, distinguished panelists and participants. I stand by the existing protocol. Based on the presentation that has been made by highly eminent panelists, I do believe very, very firmly, having regard to the tone set by the President of the Industrial Court, that the Industrial Court already has been contemplating provisions in its operations to enable expedited delivery of justice administration. And I can speak from experience that the National Industrial Court is eminently ready for the issues that are highlighted in the practice directions. I can tell that by the provisions of the rules that have been spoken to, by Honorable Justice Obaseki Osagi that routinely colleagues have taken liberal participation with respect to provisions relating to trial by the record. We have seen this in operation personally, and I can tell that what these practice directions would merely do would be to complement what the industrial court already has on the ground. For those who have listened to the eminent panelists, it is clear that what we have to take away is that this is something that the National Industrial Court has talked about extensively. We believe that having regard to the depth of penetration of telecoms within Nigeria, having regard to current developments in technology, the level of investment that would be expected to take advantage of what is contained in these provisions basically fairly exists. I do agree with most of the panelists that investment definitely is required. But most of these investments actually would be minimal. It would require, some strain on finances, but I believe that it is something that can be done with a little bit more support by the court itself. Quite a number of the panelists have indicated that the court should offer on-site infrastructure, and I believe that if we have regard to what the content of the rules provide, the rules already contemplate how those on-site infrastructure will be conducted, because the rules already contemplate a situation whereby what the procedure ought to be when we are conducting proceedings online, and what the procedure ought to be when there is physical participation within the court premises itself. So I do believe that the invitation to the court to consider such infrastructure is welcome. I also understand and actually consider discussions that have been raised by panelists with respect to the constitutionality of these provisions. Quite a number of the eminent panelists have situated that there are enough provisions within our laws that these practice directions can be anchored under. The provisions are novel, as the panelists have also all indicated, and I believe that having regard to what the practice directions speak to, what we're all trying to deal with, the emergencies that we're trying to deal with, that it is reasonable to enhance general participation in the administration of justice to ensure that these rules actually receive the support of all the participants. I can't speak more than all our eminent panelists have done. And as indicated, it is something that the court has actually thought extensively about, and I believe that there will be success in the operations of these guidelines. I do thank the moderator, Mimi Ayua, for the opportunity given to us to speak a little bit to what the panelists have all indicated. Thank you very much.
Thank you, Mr. Audu, for your presentations. We are grateful that you honored our invitation this afternoon. Distinguished participants, may I invite to the microphone Mr. Olani Ajorin. He will be giving us his perspective as a young lawyer on the implementation of the practice direction. Mr. Ni, over to you, please.
Good afternoon, the President of National Industrial Court, the Honorable Judges of the National Industrial Court President, learned senior advocates present, the panelists, and distinguished participants. I'll start my presentation from where my learned senior, Mr. Kutu, stopped on the issue of filing of processes. I'll start with the processes to be filed electronically. From originating processes, filing them or sending them through electronic means to the registry might create some problems that might arise because some counsel or the other parties might raise some issues on some based on objections if there are the processes are not well or there are some inadequacies in the processes. Also, I believe paragraph 4 of the practice directions and guidelines, the subparagraph 1, we might best work for maybe processes like written address that might not involve affidavit or deposition by witness, because if processes involving affidavits, deposition by witnesses have to be filed electronically, objections can be raised that they were not properly sworn to before commissioner for oath. So I think the subparagraph 1 of paragraph 4 can only work for written address or processes that don't need affidavit in support. So the subparagraph 2 can work with which involve physical attendance of counsel and the witnesses and the deponents to the affidavit, so that they can be sworn before the commissioner for oath before the issue of sanitizing the processes can be done. And also, young lawyers initially, on the issue of e-payment, National Industrial Code, interestingly, the payment has always been through e-payment. So on the issue of filing now, this practice direction and guidelines have made it in such a way that the lawyers concerned or the counsel would take part from the beginning of the process till the completion. Initially, you can go to the registry a day, max 1-2 hours, you file your process. But based on this, you have to, drop your documents, be communicating with them till after they have sanitized it, the 120 hours is given, and communicate with the designated officers to see that the processes are well filed and in accordance with what the parties want. Also, the challenges that might also come up is the issue of when it's an originating process. Actually, the practice direction and guidelines have made provision for service, but in the case of originating process where the contact or the email, telephone numbers of the other party is not known, that might pose a great difficulty. So by and large, I think the NIC practice direction and guidelines, after incorporating and adopting the NJC guidelines, have also moved ahead to accommodate the peculiarity of National Industrial Code. Thank you.
Thank you, Mr. Nee, for your presentations and the implementation of the notice that we heard from the bench. We have equally heard from the inner bar and, of course, the outer bar. It remains a major stakeholder in our court system to be heard. At this point, may I invite to the microphone the Chief Registrar of the National Industrial Court, who will be speaking to us on the procedural layout by the Registry for implementation of the practice direction. With due respect, Mr. CR, you have 5 minutes to make your presentation, sir. Over to you, please. Mr. CR, your microphone is muted, please. Your mic is still muted, Mr. CR, please. Thank you, sir.
Good afternoon, my Lord, the President of the National Industrial Court of Nigeria, Honorable Justice B.B. Kanyib, and other judges of the National Industrial Court, learned six here present, ladies and gentlemen. I am grateful for the opportunity given to me to make some comments on the novel guidelines and practice direction just issued by the National Industrial Court of Nigeria. To my mind, the whole essence of the practice direction is to ensure that justice delivery takes place in an atmosphere that does not compromise individual and collective safety. I am also aware that my Lord, the Honorable President, has demonstrated a lot of foresight from the day His Lordship assumed office by emphasizing the need for the court to go digital. And it was in furtherance of this that His Lordship set up the Rules and Digitalization Committee, headed by an eminent jurist, my Lord Justice Obaseki Osage. So in a way, His Lordship has actually acted proactively in setting up the committee. And I am very much aware that the practice directions have placed enormous responsibilities on us as court administrators and officers of the court. And at this point, I would like to solicit the support and cooperation of the members of the Nigerian Bar Association, because we are putting in place protocols and other measures that are intended to safeguard public safety when it comes to the conduct of business in the court. From the moment of arriving at the entrance of the court, there are measures that we are supposed to be taking. And in doing this, we have interfaced with our staff as well as the security personnel working with us on the need for civility, politeness, and for us to be very responsible in the way and manner we discharge the responsibilities bestowed on us under the practice directions. Like I've said, from the moment of arriving at the entrance of the court users, including lawyers, are expected to be screened so as to be able to ascertain the temperature level. It is also compulsory that users of the court compulsorily wear face masks when coming to the court. And where there's no compliance, the practice directions has enjoined us to politely turn back, the affected person or persons, as the case may be. Now, that has to do with securing the court premises, in our efforts to combat the spread of the pandemic. Furthermore, there's also the issue of filing court processes, whereby the preference is for electronic filing of cases, and we have publicized email addresses to which court processes and documents will be transmitted. And it is our responsibility to print out the documents, evaluate and assess, and the amount of fees to be paid duly communicated to counsel electronically as well. Counsel are expected to make the payments and revert to us by sending e-evidence of payments that have been made. Now, there's the other aspect that I'd like to talk about, which has to do with counsel or litigant having to put their documents or processes in a sealed envelope. Such envelopes are required to be labeled in terms of stating the suit number, the names of parties, and we are providing drop boxes in all our divisions and registries. The Honorable President has been very firm and very generous in his support in making those provisions. And with respect to the quarantine period of 5 days, I know, of course, concerns have been raised, and I'm very sure that the management of court will look into how to, if possible, reduce, using available technologies, the quarantine period. Okay, I can say my time is up.
Yes, sir. Thank you so much, and the Chief Registrar. We appreciate your contributions this afternoon. I understand that we have the Assistant and Chief Registrar here with us this afternoon. Can we just have your thoughts and contributions on this too?
Good afternoon, my Lord the President, Honorable Justice Obaseki, the Honorable Justices here present, and fellow panelists and colleagues. Good afternoon. Just to add a few comments on the implementation of the practice direction. We all know that the key to an effective e-filing is effective communication. So the court is actually in talks with the NDA to supply a council directory and database complete with addresses, email addresses, telephone numbers, with functional WhatsApp capabilities, to which file processes and hearing notices will be served by court. The practice direction also encourages counsel to provide more than one email address. We always advise that counsel should provide email addresses of other colleagues in the law firm or other colleagues in the institution or wherever he is representing. Counsel is also obliged to furnish the court with email addresses and phone numbers of opposing parties, be it institutions or even individuals. The court is in the process of providing permanent ID, meeting IDs for each judge. That would also be published on the website. It's going to be published as well as the cost list. On each cost list, the notice for remote hearing shall be stated on the cost list with meeting IDs of each court, except for ex parte motions, which will not be taken remotely. The practice direction also provides for physical court sittings, where it has specifically mentioned that there cannot be more than 20 people at a time in the courtroom. It further, if you read the practice direction, it further provides other requirements for how the physical sitting process is going to take place. Numbers of persons allowed per side. Some judges are already allotting times for each case, and that will also be stated on the course list. So with that, I'll also add that once you file your process, and it's sent back to you the amount you should pay, you are going to upload the receipts that you have used for payment back to the website. The only thing that will be provided for you at that particular time is a reference code, and a suit number can only be provided when payment is verified. I'll say thank you for now. If there's any other thing, we'll answer on the Q&A. Thank you.
Thank you, the Assistant Chief Registrar, for your contribution. So we appreciate that. Milord, the President of the National Industrial Court of Nigeria, Milords, Honorable Justices of the National Industrial Court of Nigeria, here present, distinguished erudite panelists and distinguished colleagues this afternoon. We have discussions this afternoon, but may I, with the kind permission of Milord, the President of the National Industrial Court of Nigeria, take some comments and contributions. I have realized that most questions have already been answered by our panelists, in the Q&A box. And so I may not have any need to ask any questions, particularly apart from some that were directly asked to specific panelists. So Milord, may I, with your kind permission, proceed to take one or two contributions and questions, sir?
It's okay.
Thank you, Milord. We're most grateful, sir. We have a contribution here. Okay, well, maybe a question seeking further clarification from you, Milord. It talks about the computation under paragraph 9 or so of the practice direction. And it talks about, it says, to my understanding, this clarification is being sought by Mr. Godwin Etim. And he says, to my understanding, however, the provision of paragraph 9 of the directions is very specific in that it relates only to the period of the lockdown. Since the directions will still apply post-COVID-19, I do not think with respect that paragraph 9 will apply to processes to be filed in court after the lockdown. The implication will then be that a party will be liable to payment of default fees, even though he had brought his process to court for filing within time. I will appreciate if your lordship can provide further clarity. Milord, over to you, sir, if there is any need.
To start with, the practice direction, am I being heard?
Yes, Milord. Yes, Milord.
Okay. You'll have to excuse me. I'm having issues with the laptop and the service there, so I had to turn to my phone. So I'm
Very
using
well,
the
Milord.
phone for audio and using the laptop for video.
Very well, Milord.
You can see how we adapt in Nigeria based on our problems of infrastructure.
Yes, Milord.
But the point is, the provision in the practice directions already indicate that the COVID period is not to be used for computation of anything. And the last time I checked, we are still within COVID period. So strictly speaking, the question of paying default fees and so on for this period will not arise, for the simple fact that this is still the COVID period, and consequently, it will not be used for computation of time. I saw quite a number of questions while the panelists were talking, and I tried through the chat medium to answer some of those questions. Hello?
Hello, Milord, we can hear you. Thank you very much, Miss. Sorry, sir, I don't know if, Milord, you can proceed, sir.
Okay, so that's for that. The other thing I need to emphasize, really, the question of constitutionality or non-constitutionality. The provision for hearing in public is in which section? Is in section 36 of the Constitution. Section 36 of the Constitution deals with what? It deals with essentially with fair hearing. Am I being followed? Hello?
Milord, we can hear you. Yes, Milord.
Now, section 36 deals with fair hearing. So, whether you are for constitutionality or you are against it, the question you need to answer is a very simple one. Hearing in public, or what other laws call open court hearing, is it an end in itself? I repeat that question. Open court hearing, is it an end in itself or a means to an end? Now, if we take the view that section 36 of the Constitution deals with fair hearing, and hearing in public is within the structure of fair hearing provisions, then it means that the issue of hearing in public is geared towards the end of fair hearing or justice in itself. It was Lord Sten who said, in law, context is everything. So when we are dealing with an issue, when we are faced with a problem, I always like to ask the question, in what context were the provisions made? These provisions, as we have them today, I think, if my history takes me well, came about in the 1979 Constitution. And it was repeated in the 1999 Constitution. So I take 1979 as the baseline. In 1979, did anybody foresee COVID? The answer is no. If COVID was foreseen, would we have been restrictively defining in public as we are trying to do today? The answer is certainly no. So what does in public stand for? In public, within the context of fair hearing provision, deals with access. Whoever wants to access the court system should not be hindered. So if you do a virtual hearing where access is not denied, how can that be not in public? Once the public is given access, whether you utilize it or you don't utilize it is up to you. But so long as access is not I think it was Justice Nikki Toby of blessed memory who defined in public as anything that is not in private is in public. What is it we are doing that is shrouded in secrecy? What is it that we are doing that is shrouded in privacy? As to say that we are not doing it in public. My call to lawyers: understand the context in which a provision is made. Then you will easily apply it to given fact situations. I agree with Professor Amuchiazi, who said it is not for every little thing that we go amending constitution. We had an issue when late Yaradua was still in power. He was sick. We ran an amended constitution. We are having an issue with COVID. We are running to amend constitution. Meanwhile, nobody has sat down, like Professor Amuchiazi has said, to ask, what is the cost of each constitutional amendment? Don't forget, COVID is going to have a very negative impact on our economy. We are going to need every kobo that we have. We are going to need every kobo in post-COVID period. How much are we going to spend for National Assembly to amend Section 36, for 36 states houses of assembly to meet and ratify before it comes back and then goes for assent in the president, when this is a simple issue that through constitutional interpretation can be sorted out? Sometimes we make, how is it they put it, a mole out of an anthill, or what is the saying? Sometimes we need to look at the context in which some of these provisions are made. Then and only then can we specifically be able to put in place measures. I always like telling lawyers in court, never forget, in law, context is everything. Over to you.
Thank you, my lord, Honorable President of National Industrial Court of Nigeria. Thank you for graciously obliging us your thoughts and on the submission earlier by Mr. Joshua Olukayode Olatoke, SAN. Flowing from that, we have contributions from Dr. Joshua Musa, SAN. In that regard, he cited the Supreme Court authority, Garuba versus Unimade 1986, 1 NWLR Part 18, page 55, particularly at pages 596 to 597, per Justice Esso, which he said it would be safer for the courts in this country to err on the side of liberalism whenever it comes to the interpretation of fundamental provisions in the Constitution than to import some restrictive interpretation. A liberal interpretation of public within the meaning of Section 36, sub 3 of the 1999 Constitution cannot exclude virtual hearing. And so he goes further to, of course, agree with the former Attorney General of Enugu State that the NJC lacks the powers to make rules to regulate proceedings in our courts. Just to support the comments of my lord on that. Distinguished panelists and participants, may I at this juncture invite all the panelists for their final comments as we round off this session. Permit me to begin with my lord Honorable Justice, I beg your pardon, my lord Honorable Justice O.A. Obaseki Osage, as she makes her final comments. My lord, over to you, please.
Just before that comment. Just before
Okay,
that comment.
Yes, my lord.
I forgot to say something about the NJC guidelines. Am I being heard?
Yes, my lord, we can hear you, but we have this
Now,
echo.
if you go to the powers of NJC, in the, I think, third schedule or so, to the Constitution, there's a provision there that gives NJC power to formulate policy. I remembered a colleague of mine who is a judge of the Lagos High Court actually sent me a note some weeks back on this same issue, the constitutionality of NJC giving directives to courts, where is the concept of federalism and so on. Go back and read the guidelines of NJC. NJC has given the guidelines as a policy-making body and then urge each head of court to adapt it according to the specific needs of the court. I tell people casually that some of us as heads of court waited for the guidelines before issuing our own, not for any reason, but principally for two reasons. One, if NJC gives you a policy and says you can act in this manner, as a head of court, if you act in that manner, you are on familiar territory and on familiar ground. You can afford to say, yes, there's a policy direction and we are acting on it. And if for any reason what you do goes for appellate review, you are on good ground to say, I did this based on a policy given by NJC. So when you assess what I'm doing, you are not just assessing what I'm doing, but also assessing NJC in terms of its power to have given that policy. The second reason, and this is useful for lawyers, particularly those who are petition hungry. Whatever I do, if it is based on a policy given by NJC, what it means is that if tomorrow you have problems with it and you decide to write a petition against me on it, I am acting on safe ground. Of NJC that suggested those guidelines, they were 10. They were 10. And those 10 included judges and members of the bar. In fact, it was headed by the Supreme Court. Whatever you see in those guidelines took the account of not just views of those on the bar, on the bench, but the views of those at the bar. I want to make a statement. As soon as COVID started, the Supreme Court of India came out and issued not a judgment, but a policy statement that virtual hearing is not unconstitutional. Virtual hearing is not against the open court system. Maybe, just maybe, we need that kind of statement from the Supreme Court. I wonder aloud, if tomorrow we see the Supreme Court sit virtually, would anybody be talking about unconstitutionality of virtual hearing? I really wonder. Thank you.
Thank you, my Lord, Honorable President of the National Industrial Court of Nigeria. Thank you very much for your insightful comments. May I, at this point, invite to the microphone for her final comments, my Lord, Honorable Justice O.A. Obaseki Osagi, the chairman of the Rules Committee of the National Industrial Court of Nigeria. Over to you, my Lord.
Thank you very much. A final word. There's no doubt that the practice directions of the National Industrial Court is a harmonization of the guidelines of the NJC and our practice directions. We have tried as much as possible to make it user-friendly. User-friendly to counsel and user-friendly to those litigants who have decided not to engage counsel. And of course, we urge Council to look very carefully at the directions, particularly for this COVID period, and try as much as possible to see where they can use the provisions, particularly because of speed, and having it at the back of their minds that labor matters, matters that should not really be left lingering, because in most of the cases where you find a litigant has lost his job, his entire livelihood and family and dependents, livelihood at stake. So I urge Council and litigants to, as much as possible, where they have matters that are pending or where they have decided to file new matters, to use the procedure for trial on the record. Thank you.
Thank you very much, my Lord, Honorable Justice O.A. Obaseki Osage. Flowing from that, before I relieve you, to finally rest this afternoon, there is a question or comment, so to say, here for you that says that, is it possible or practicable to direct registrars of the court to inform Council by email address or text messages on the specific time to come for the assessment of fees to be paid for their processes after the expiration of the 120 hours quarantine period? This is to avoid Council being forced to queue for assessment of fees to be paid. This will no doubt also aid in ensuring that we observe social distancing principle stipulated by the WHO. I don't know if you have any comments to make. I just wanted to read that out to you, my Lord, Honorable Justice O.A. Obaseki Osage, please.
Yes, thank you very much. I don't think there's any difficulty there, because I expect that all the lawyers have their email addresses. And of course, once you use the Dropbox system and your processes have already been looked through and it is ready, filing has been completed, sorting has been completed, there's absolutely no reason why the registry will not send a message to Council by email that it is time for you to come over and sort out your process. Yes, thank you very much. And I'm sure the Chief Registrar and the Assistant Chief Registrar will take note of that and implement it. Thank you.
Thank you very much, my Lord. We are most grateful for your time and audience this afternoon, and for noting our points and suggestions. Thank you so much. May I, at this juncture, invite for his final words and comments, the government perspective, the Solicitor General of the Federation and Permanent Secretary of the Federal Ministry of Justice, Mr. Dayo Akpata, SAN. Mr. Solicitor General, sir.
Yeah, thank you very much. Can you hear me?
Yes, sir, we can hear you, sir.
Okay, my Lord, the President of NIC, distinguished participants, know that the conversation today has been very fruitful, and I'm sure we have all been well informed and even more educated as to the practice direction. We have to agree on one fact, that by these new innovations, there will always be continuous argument for and against, which is why I will subscribe to err on the side of caution, that we should allow amendments to the Constitution. Why do I say this one? This will allow for uniformity. It will reduce overheating arguments and unnecessary litigations, and even appeals. Sometimes we go on appeals because not that we have lost, but we have lost little weight. If we can have an amendment, then we will know that the issue of going on appeal over some issues like this will not come up. And or in the alternative, we escalate it to the Supreme Court, so that at least we want to thank the Lord for having that mind to go into the practice direction and go into virtual hearing. What of the leadership is not really disposed to it? So for a uniformity in Nigeria, there will be a need to either escalate it to the Supreme Court or we amend. I want to thank my Lord for the effort and industry. Thank you very much.
Thank you, the Dayo Akpata SAN, for your final comments. We are grateful for your time spent with us this afternoon. May I, at this point, invite Mr. I.O. Olorundare SAN for his final comments. Learned Senior Advocate, sir.
Hello. Yeah,
Yes,
thank
sir,
you
we
very
can
much.
hear you, Learned Senior Advocate.
Okay. My Lord, the President of the Industrial Court, my Lord Obaseki, I thank you all, my co-panelists and the participants at this feature hearing, I must say. My first contribution, because of the technological challenge I had, I couldn't contribute very well. But I have to say one or two things, and that is in respect of section 36, subsection 4A. It puts it beyond our adventure when it says that a court or tribunal may exclude from its proceedings persons other than parties thereto or their legal practitioners in the interest of defense, public safety, public order. Now, why I want to emphasize this is this. Some people have commented here that it applied only to the criminal cases. I shudder to disagree with them in the sense that when you are construing constitution, as said, enjoined by Supreme Court in Nafi Rabiu against the state, you have to construe it liberally in order to give meaning to it. The operative words there are from the proceedings, persons other than parties thereto or their legal practitioners. It says parties, their legal practitioners. There is no need for us to say we want to amend the Constitution again. When you look at that particular provision, you will see that it stands independently, though it was subjoined to sub-paragraph 4 of section 36. But when you look at it, it says parties and their legal practitioners. It did not make a distinction whether it is parties to criminal matters or their legal practitioners. It says parties, so which includes everybody. So you cannot narrow it down to just criminal cases. And you have to approach the Constitution from, you take every part of the Constitution when you want to construe it and interpret it. You just don't limit it to a particular section like that. And everything, you have to consider it holistically. Again, I do not, with respect to the Solicitors General, feel that we need to escalate this to the Supreme Court, in the sense that even the Supreme Court is on a pilot stage of doing factual hearing now. They are exploring it. They are right away on it, that which I know very well. So if the Supreme Court is about sitting, using the factual hearing, we should know that they are considered, the judges and the Chief Justice of Nigeria are considered the provisions of the Constitution, and that is why they too are now saying that most of these things have to be heard through factual hearing. And then again, when we look at what my Lord, the Honorable President of Industrial Court said, I had the privilege of reading the practice direction of the Chief Justice of India, where he said factual hearing is not against public hearing. We have to be proactive in our thinking. We should not just be waiting for the industrialized court to be taking shine every now and then, and for us to be saying, why is it that we cannot do this thing in Nigeria? We should be able to be doing this type of a thing. Don't let us wait. When we start with trial and error, we will eventually get to where these industrial costs have gotten to. So that is my own view about the whole thing. The virtual hearing is not unconstitutional. It is constitutional. All the cases that are cited were not decided based on Section 36, subsection 4A of the 1999 Constitution. I thank you for informing me in this exercise. Very grateful to you for calling on me to be one of the participants. Thank you very much.
Thank you, Leonard Senior Advocate of Nigeria, Mr. I.O. Olorundare. Please do not exit. We have a very important function. I now invite Leonard Senior Advocate of Nigeria and the erudite Prof, Mr. Peter Akpe, SAN, for his final comments, please.
Thank you very much for. Basically, I would like to say that the discussion we've had this afternoon has demonstrated the utility of the practice directions. We have been able to see from the various discussions taken that the practice directions are actually very useful. And without them, perhaps, it would have been difficult for us to achieve the purpose for which they were made. So the rationale has been brought out very clearly, I must say. And the point to note really is that the practice directions were issued because there were new circumstances which were not covered by existing rules. So they are meant to deal with new situations. They are also meant to take on board the innovations that have been put in place in response to these new situations. Therefore, council and indeed all court users must align themselves to this thought that, look, these practice directions were meant to serve a purpose, and construe it and work within the provisions of the practice direction to achieve the purpose for which they were actually issued. On the flip side, I also want to align myself with the thoughts expressed by Olorundare and indeed others, including Professor Amuchiazi. I feel that we can't get to a point where at every point in time we will be advocating for constitutional amendment over issues that we believe the courts, through their interpretative powers, will be able to deal with and clarify. So we shouldn't be insisting at all times that once we appear to see some difficulty or challenge in the implementation of certain provisions of our constitution, the next step should be constitutional amendment. I think that we're taking it too far and making the process of constitutional amendment rather flimsy if we have to go before the National Assembly every other time we have a little challenge like that. For me, and I believe very strongly too, that we shouldn't get to a point where procedural issues, because the Constitution has already given the judiciary the power to hear and determine cases. Now, virtual hearing is a method of hearing and determining cases. So should we also write into the Constitution the procedural issues relating to how courts will hear and determine issues? I think not. So that is how I believe, and I strongly believe that we should align ourselves with the thought that it's not unconstitutional. Thank you very much.
Thank you, erudite Prof. Mr. Peter Akpe, SAN, for microphone, Mr. Joshua Olukayode Olatoke, Senior Advocate of Nigeria, for his final comments this afternoon. Leonard, Senior Advocate, sir. Leonard Senior Advocate, Mr. Joshua Olukayode Olatoke. Senior Advocate of Nigeria, Mr. Olukayode, please, you need to unmute yourself, sir. We cannot hear you.
Hello? Hello?
Yes, sir, we can hear you now, sir.
Okay, I said I want to appreciate.
We can hear you, Leonard.
I want to appreciate the prophetic president of National Industrial Court, who has been proactive as at the time of commencement of his tenure by providing for digital and electronic filing, which is towards the virtual proceedings. And it has taken us thus far. So, and concerning the submission I made earlier, I'm still of the view that to stay on the side of caution and not to fall a victim of what happened in Oji Uzo Kaslu's case, where proceeding of 9 years was nullified few weeks ago. It will be better to stay on the side of caution by making a case stated to Supreme Court to interpret section 36, subsection 4 of the Constitution, even if we are not going to fall for amendment. So that is my view. Thank you.
Thank you very much, Leonard Senior Advocate of Nigeria, Mr. Joshua Olukayode Olatoke, for your final comments. Thank you. May I invite to the microphone for his final comments, Professor Ofonze Amuchezi, SAN. Over to you, sir.
Thank you very much. I'd like to commend the National Industrial Court for the innovative practice direction that has been introduced. And let me just say that virtual court hearings are here to stay. We can't run away from it. I still maintain my position that it's constitutional and there is no need for any further amendments. I believe that our courts a liberal interpretation of the provisions of section 36(3) so that we can make meaningful progress. And I think the National Industrial Court has taken a step in the right direction. I also want to use the opportunity to urge our colleagues. We all have to key in into what is going on. We can't run away from it. The world is fast changing and we've entered a new normal. And whether we agree or not, this is the new normal that we have to live with, both in this country and outside this country. And thank you for the opportunity to make my contributions to this discourse. Thank you very much.
Thank you very much, Leonard Prof. Ofonze Amuchezi, SAN, for your final comments. Thank you. May I now invite to the microphone for his final comments, Mr. P.H. Ogbole, SAN. Do we have online? Okay. I apologize for that slip. May I at this point invite to the microphone for his final comments, the former Attorney General of Enugu State, Mr. Nduka Ikeyi.
For the opportunity.
Hello, sir.
Can you hear me now?
Okay, we can hear you, former Attorney General. Please make your final comments on behalf of the outer bar, please.
We are pleased to have participated in this discussion, and we hope that going forward, we'll see the benefits of the innovation. There continue to be areas of disagreement, but I believe that we'll work through that as we move forward. Thank you very much.
Thank you very much, the Honorable former Attorney General of Enugu State. May I, at this point, please invite back to the microphone Mr. Ayo Olorundare, SAN, for his vote of thanks, particularly to the bench for hosting this bench and bar forum this afternoon. Leonard, Senior Advocate, sir. You may have to unmute your mic, sir. Very well.
I hope I'm in order now.
Yes, sir, you are in order, Leonard Silk.
Okay. My Lord, the President of the Industrial Court, Honorable Justice Kanyip, Justice Osage Obaseki, I thank you for putting together this as the chairman of the Root Committee of the Industrial Court. This is a wonderful piece of job that you people have done at this end, and it's highly commendable. You have put the bar on the toes so that we have to be running, just as the court itself must be prepared to be running with us. And I know that you must have done your in-house job to do this before you churn out this practice direction. It is a wonderful piece of a guideline that can withstand the test of time. And you must have done a very thorough research before coming out with this. And I thank all my other colleagues, my learned brothers of the inner bar, for their resourcefulness. The members of my other colleagues from the outer bar, and the participants who have been sending us a lot of questions to let us know the thinking of the members of the public. We are very grateful to every one of you. I thank you very much on behalf of the court and on behalf of other participants, the erudite contributors here, and then the moderators and the administrative supporting staff of the National Industrial Court. I pray that every one of us will be greatly rewarded with this, but not with COVID-19. We shall see the end of this COVID-19 successfully, so that our life will come back to normal, and then we leap forward from here. Thank you very much. God bless you all. Have a wonderful day.
Thank you very much, Mr. I.O. Olorundare SAN, for the succinct vote of thanks. Distinguished participants, may I at this point crave the indulgence of my Lord, the President of the National Industrial Court of Nigeria, my Lord Honorable Justice Benedict Bakwa Kanyip. May I please seek his permission to close this meeting. My Lord, may I humbly—
Go ahead.
No, my Lord, may I most respectfully crave your own indulgence to help us close the meeting, sir.
Oh, you want me to close it?
Yes, my Lord.
Okay. I thank all of you for your very honest views, comments, questions, and interests, really. I pray that as the learners prayed, we'll all go home in peace without COVID. We'll see some of these things through, implement some of your suggestions. Above all, we pray that there will be money to put the infrastructure in place for everything. I thank you all. God bless and stay blessed.
Thank you, my Lord, the President of the National Industrial Court of Nigeria. My Lord, the President of the National Industrial Court of Nigeria, my Lords, Honorable Justices of the National Industrial Court of Nigeria here present, erudite panelists, distinguished participants, ladies and gentlemen, It has been an insightful session this afternoon. We thank you all on behalf of the Committee of Legal Practice of the Nigeria Bar Association, and we pray that God continues to bless you as you continue with your own endeavors. At this point, this meeting stands closed by my Lord, the Honorable President of the National Industrial Court, and it has been an honor moderating this session. My name remains Mimi Ayua, and I look forward to seeing some of you some other time. Thank you very much. It's good afternoon from this end.
Good afternoon, Mimi. Thank you.
Thank you, moderator. Stay blessed.
Thank you, Mimi.